This is the protection of the environment under the Rome Statute, or I will give you a much wider field, a much wider perspective. So I will give you a general overview of the protection of environment during armed conflicts within the relevant legal frameworks. So the protection of the environment during the armed conflict, I have in this respect for the environment, I think we have two clear directions. The first direction is an ecocentric approach. Actually, I have to clarify here that I'm an international environmental lawyer, so I have some connections to international criminal law as well, or international responsibility as well, so the state responsibility as well. However, I'm an international environmental lawyer, so my perspective is rather focusing on the international environmental horizon. So in this respect, the environment within an ecocentric approach is an object to be protected for itself. So this is the ecocentric, which taking out of consideration of the human standards and the humankind. And the other direction, which is much more closely to the international criminal law field, is that the protection of the environment is an essential tool for the protection of individuals or the group of individuals. And for this focus of the conference, the second direction will be the answer. So I will focus on the second direction. Okay, when the protection of the environment will be a tool, an essential tool for the survival of humanity, humankind, and also for the protection of the individuals. Sorry for my overcrowded slides. I will not read upon all the lines. It is just for giving you the big picture. The first slide is about the ecocide, which is a very catchy term. Appeared a couple of decades ago, however, it has a special meaning nowadays, and also from previous years, by the work of the independent expert panel for the legal definition of ecocide, we have a brand new definition we can work with. Because the ecocide is, okay, it is a commonplace, it is not so a brand new information to you, that the ecocide is not a direct international war crime and it is not an international crime. But some forms of ecocide can be labeled as a crime. We will check the Rome Statute and the relevant paragraph and the relevant article of the Rome Statute. However, the best definition we have is from 2021, when the independent legal expert body, however, it is a non-binding definition, and you know it is softer than soft law. There is a panel chaired by the famous international environmental lawyer Philip Sands. He's a co-chair of this body. The other is a lady from Africa. And they pronounced the definition and the special kind of an amicus curiae for the court or for the states to include the ecocide into the Rome Statute. And you can see this proposed amendment of the Rome Statute, namely the Article 8 ter article, defining ecocide, and which is much more important, defining special elements of ecocide. And I want to raise your attention to the words severe, widespread, long-term, because we will see these words later from the relevant international norms and from the relevant definitions. So this proposed amendment want to include the ecocide as a crime into the Rome Statute, and including the definition of the most relevant and essential parts of ecocide. And the Office of the Prosecutor of the ICC also highlighted that, quote, the destruction of the environment, the illegal exploitation of natural resources, or the illegal dispossession of land can, unquote, can be considered war crimes. It is a policy paper on case selection and prioritization from 2016. So what are the elements? What can be the potential elements of ecocide? Very first, it is very necessary to include the environment as a victim. So can we label the environment as an object, as the victim of a crime, of an omission or an other activity? The second one, and I will go back to this issue later, rights of the environment and nature. And in some countries we have, international environmental lawyers can witness very promising, very progressive, brand new trends by giving legal personality to natural objects. Like in the case of Ecuador, in the Constitution of Ecuador, there is a provision that the natural elements can be protected by the law in the form of personality as well. The New Zealand Parliament, a couple of years ago, adopted a law on giving legal personality to Wanganui River. Wanganui River is very famous because Wanganui River is a symbolic river for the Maori minority. So therefore in the political life and also the cultural life of New Zealand, it is a very specific river. And on behalf of the Wanganui River in New Zealand, a public prosecutor, an ombudsperson, or a green NGO can make a judicial claim against a polluter, against anybody. And also we have very promising trends in the animal rights sphere as well, which is also very interconnected with the protection of the environment as an object. Like in the case of Argentina, a couple of years ago, and it is a final and effective judgment, the latest instance, that Sandra, the orangutan, which was held captive by a circus entertainer, a circus owner. And the Green NGO made a claim against the circus entertainer and an owner of the circus that the capture of the animal was inhuman, outline inhuman, degrading, and it was very bad for the animal. And therefore, the Argentinian judge and the court of Argentina stated that yes, Sandra the orangutan has a right to liberty, and therefore they shall release, and afterwards they released the orangutan, and now this animal, this ape, is living now in an animal sanctuary in Florida in the US. So therefore, we have a very brand new and progressive trends of giving personality, of giving rights to natural elements. So these rights of the environment, rights of the nature can be a very important element of labeling something as an ecocide. The meaning of harm. What is the harm, the negative and the detrimental effect in the protection of the environment? Can we call a climate change, which is an ongoing issue and an ever-trending issue, an evergreen issue worldwide, can we call them as a concrete harm and a concrete damage? Because it is very, very difficult to include that what is the relevant and what is the responsibility behind the climate change. Because we all know that each country is responsible for climate change. But when we call that each country is responsible, meaning no concrete country will be responsible, because everybody's responsibility is nobody's responsibility in that sense. And also the causal nexus. In environmental law, the most severe problem is the causal nexus between the state activities or omission and the damage of the environment, namely the climate change or other detrimental effects. So we shall find these elements and we shall include these elements into the definition of ecocide and into the horizon of ecocide, and afterwards we can call it as a legal theory, and then afterwards we can include them, or the state can include them into the Rome Statute. However, I'm very hesitant, and I'm also very maybe pessimistic or idealistic. I don't see any chance that in the coming future, in the next years, they will include the ecocide into the Rome Statute. So I'm not a super progressive on that issue. I'm a bit hesitant, and I will be very cautious to label the ecocide that it shall be an international crime. So the focus of my presentation, that I will give you some insights of the Rome Statute in relation to the protection of the environment, and then I will give you the list of the relevant treaties which can be applied during armed conflict, and they are also related to international environmental law. I will give you 2 examples for the sources of customary international law, including state practice as well, relating to the protection of the environment. And I will give you also non-binding documents. So let's start first with the Rome Statute and the expressis verbis mentioning, the explicit mentioning of the protection of the environment. It is also very familiar to you, the Article 8.2, para B and 4, Latin with Latin letters 4. The intentionally launching of an attack when this attack will have a detrimental cause and will cause heavy harm on the environment. So it is under the war crimes. And the elements of these war crimes, when we can see that the protection of the environment or the using of the environment for a war crime, so there shall be an intentional launch of an attack. There shall be the knowledge that such attack will cause incidental loss of life or injury to civilians or damage to civilian objects, and widespread. Just think about again the ecocide definition from the independent panel experts. Widespread, long-term and severe damage to the natural environment. And also, and which is I also highlighted on the slide, that the most problematic part of this definition, part of this Rome Statute Article 8, that which would be clearly excessive in relation to the concrete and direct overall military advantage anticipated. The problem is that this advantage is rarely officially, is rarely communicated or unfolded in an anticipatory manner. So therefore the military necessity and the military advantage is also very questionable, and we cannot call it is super certain that what is the in an anticipatory manner which will be a direct and concrete overall military advantage. So it is very hard to find out. And therefore, when the military necessity or the military advantage is not crystal clear, then we will have a problem to apply this part of the statute to the Rome Statute. And implicitly, because beyond the war crimes, when the protection of the environment or the usage of the environment is explicitly mentioned, we can call that some implicit mentioning or some implicit content of the protection of the environment can be found within the articles of the Rome Statute, like the genocide, Article 6, para C, the deliberate inflicting on the group conditions of the life calculated to bring about its physical destruction in whole or in part. And the crimes against humanity, Article 7, other inhumane acts of a similar character intentionally causing great suffering or serious injury to body or to mental and physical health. And in the protection of the environment, and I will give you an example. A couple of years ago, and sorry for giving this example from the field of international environmental law, maybe you have heard about the Maldives and the Maldive Islands. The Maldive Islands is the lowest lying country all over the world. And actually, I'm not an expert in natural sciences, but natural scientists and climate experts said that 3 or more meters higher, when the sea level is rising 3 or 4 meters higher, the Maldive Islands will disappear. Maybe tomorrow, maybe 20 years later, maybe 200 years later, but it definitely happen. It will definitely happen. And can we say that, okay, everybody knows that, even the panel, the UN panels declared this statement that it is a concrete and danger, and it is very actually it will happen. And we all know that all states are aware of the fact that this kind of danger can be caused in the future, and we are not giving any importance to that, and our climate change treaties are also weak, and the application and the implementation of the international environmental legal standards are very poor. So can we call that all the states will be responsible for the vanish of the Maldives in the coming decades or the coming centuries? Actually, we don't know, and I won't call it that it will be a genocide or something else. So it is not an environmental crime, it is not an international crime, but one can say that, okay, in a theoretical way, we can discuss about it. Okay, but I won't say that it is an international crime, I have to say. But some stated that it is implicitly a very important issue to raise. And the relevant treaties, and also sorry for this overcrowded slides. From the two slides, I will highlight two, I think the most important two international treaties, binding treaties. The first one can be seen on the first slide. It is the so-called ENMOD Convention, the Environmental Modification Convention. It is based on the UN, so a UN-based convention, meaning that there is a prohibition of using those techniques, environmental modification techniques, which are hostile to the environment and which will be very dangerous to the environment as well. And also it defines the environmental modification techniques as well, but it is just very important that it is not related, not clearly related to the ICC. It is just, protection of the environment during armed conflicts. So it prohibits such manners which are hostile to the environment by using environmentally modification techniques. And the second relevant treaty, the most relevant treaty, is the Protocol 1 of the Geneva Conventions, when we can say that two articles are clearly connected to the protection of the environment. Article 35, basic rules, you can see that it is prohibited to employ methods or means of warfare which are intended or maybe expected to cause widespread, long-term, and severe damage. Also a familiar term. Just remember the Philip Sands-based independent expert panel. Therefore, they wanted to define the long-term, widespread, and severe damage, but it is very important. What is the damage which is severe? What is the damage which is widespread? Can we call that a general a climate change issue is a severe and long-term and widespread damage? Because if we can, it is also connected to the Article 8 of the Rome Statute. So we can find these three crucial words: widespread, long-term, and severe damage to the environment within the mentioned Article 8 of the Rome Statute. And also Article 55, the protection of the natural environment as well. We will see the same paragraph, maybe the same wording later in the International Law Commission's brand newly, 1 year later, adopted draft principles. I will go back this issue. So the customary international law and other relevant documents, and I know that international criminal law is not about customary international law. But international environmental law is full of customary international legal principles and standards as well, like the common but differentiated responsibility. So we cannot call it, and we cannot use the common but differentiated responsibility beyond the international legal standards. We cannot apply this norm in international criminal law. Okay, it is not about international criminal law. International criminal law, common but differentiated responsibility, it is out of question. It is just for the international environmental legal standards. So the two main sources I want to raise, and I want to raise your attention to the 2020 guidelines of the ICRC on the protection of the natural environment in armed conflicts, And the second one, the later one, 2022, the draft principles on the protection of the environment in relation to armed conflicts adopted by the International Law Commission. For the first document, which is customary international law, or maybe softer than customary international law, so it is softer than soft law. So, however, the guidelines of collected by the ICRC, maybe we can call that, according to the international environmental legal standards, these rules and two recommendations can have some customary nature from international environmental legal perspective, but not from the international criminal law perspective. Okay, so even international environmental law, they are called as customary international law. Also, we have other relevant parts and rules. We have plenty of rules from the guidelines of the ICRC. And which is brand new, the International Law Commission draft principles. It is very important that just principles and not draft articles. Draft articles, okay, I need 1 more minute, I think. The draft articles are parts of, can be customary international law as well, like we have seen in the case of the international responsibility of states. However, the draft principles are even softer than those kind of articles. However, it is very important that this International Law Commission's draft principles mention the Martens Clause to the environment. To the Martens Clause to the environment, which can be seen on the conclusion slides as well. So the problems ecocide only in the legal literature. So it is a very soft law terms, and it is from the independent panel without clear definition. The victimization of the environment, just think about the object, environment as an object. The problems within international environmental legal norms, the causality problems, the culpability problems, the direct link between the act and the result, the outcome. And also we have Martens Clause for the environment that in the case of the shortage or in the lack of relevant international criminal or environmental law provision, we shall focus on the protection of the environment in relation to the survival of humanity, public conscience, and for the good of the environment. So I think this is the biggest invention or collection of the International Law Commission's work, that they put the Martens Clause for environment. And also, so we have shortages and obstacles, but we have promising trends as well, like the environment as a protected object. Maybe the environment or the elements of the environment can be a protected object according to some treaties. We are not witnessing this trend, but maybe in the future, as I have mentioned several constitutions and also the Argentinian judicial decision as well. Maybe we will see it later. And also we have maybe a trust of the ILC draft, the draft principles, whether this kind of soft law or even softer than soft law, so the draft principles of the protection of environment during armed conflict, maybe it has some impact later in the international sphere, maybe in the form of customary international law, but it is just on the long run. So that was my presentation. I want to give you some connections between the international environmental law and the protection of the environment and some kinds of international crimes and the Rome Statute. Thank you for your kind attention.